So we'll start with a simple question for Robert. What is copyright?
So copyright is the type of intellectual property right that covers creative works. So the first thing to say about that is that it's a type of property. Intellectual property is a type of property in the same way as a house or car is a type of property. It's something that can be bought and sold and dealt with as if it was a physical thing, even though it's intellectual property, which means that it's not physical. It's the rights in your screenplay or in your novel or your book. So copyright covers literary works, dramatic works, which are going to cover most of the things that guild members are going to write, but it also covers things like musical works and artistic works as well. And it gives the owner of that copyright the right to basically do anything with that work in terms of exploitation. So the right to copy the work, to distribute it, to broadcast it on television, or to screen it in public. All those things are the rights that the copyright owner holds. Copyright is also kind of unusual in that it comes into creation immediately on creating the work. So there are no formalities with copyright beyond the fact that you need to actually have the work in a physical form. So it needs to be written down in some form, which could be with a paper and pen, or could be on a laptop and saved as a file. It doesn't really matter. So the qualifications for copyright are very easy to qualify for. It doesn't need to be registered. There are registration services you can think about using, but that's more about kind of making sure that you have good working practices. That because copyright just comes into creation when you create your work, you need to have a way of keeping track of what you're actually creating.
So when you say a registration service, they're like Script Vault, somewhere where you can send copies of your work and they hold a copy, a bit like if you also have a will and they keep a hold of someone keeps hold a copy of it.
Yeah, that's right. So the important thing is to make sure that that your work is recorded somewhere, that you know what you're creating. So if there's a question in the future about who created the work first, or who did you really create it, you've got something to show that you did. You've got some evidence to show, yeah, this is when I created this work, this is the draft. What I personally do when I'm writing stuff is I save the work every day with the day's date on it, and I save every day's work like that, because actually every day's work, everything you're adding to the script adds to the copyright. It's a new copyright in whatever you've created that day, and that way what you're building up, okay, it's a lot of files, and you can dump the files down onto a drive or something when they get too many, but you're basically showing the way that the work has evolved. So if there was a question about how the work was created, you'd be able to produce that from a blank sheet of paper right up to the final draft.
Brilliant.
So it's about working practice, about making sure that you know where your work has come from and proving that it's you who have written it.
Now, what happens if there's two of you working on a new project? What sort of steps do you have to take then?
So there's kind of a legal issue there, because one person writes the script, they own the copyright. The person who writes the script or creates the work owns the copyright first of all. They don't need to do anything to claim ownership, they just own it. If there's more than one person, then the question is, who is creating what, and how are the collaborators working together? If they are working together, like in the classic, way of Galton and Simpson, or someone sitting in a room firing ideas back and forth between each other and typing them down, then they have they're called joint authors of the script. which means that basically the contribution of each person can't be distinguished. Yeah, and in that case, they both own all of the work together.
Right.
The alternative to that is if people are, say, creating the work separately, one person does a draft and sends it to another person who does another draft, or creates another draft, does another half of the script or something, then they are co-authors of the copyright. The two different copyrights can be distinguished. You can find out who wrote what, and that means that each person owns the copyright in their part of the script, in whatever they wrote.
Okay.
Yeah? And so the important thing is, if you're working with someone, you have some kind of collaboration agreement that says who's going to own what and what are the circumstances which each person can make use of the work. Because the problem with collaborations is they're great when they work, but when they don't work, people start to say, well, actually, I created that, I want that, that's my character, I wrote that line, I'm going to develop something from that. And so you need to basically have a way of working out who's going to get what before you start, and that's in a collaboration agreement.
And John, would I be right in saying that we get a lot of calls into the Guild where those relationships have gone wrong?
Absolutely, and I'd say 99.9% of the cases I really get are where those relationships, or where relationships between a writer and producer have broken down. And one of the things that I'll always say, and I always say to everyone, is make sure you've got an agreement up front before you start doing any work. As Robert said, collaboration agreements are a good thing to use if you're going to be collaborating with another writer to produce a piece of work, because there's something you can refer back to go, well, actually, I'm going to say that we own this 50, we're going to own this 50-50. This is how we're going to make decisions on this piece of work. And also those agreements can cover what's going to happen if that relationship does fall apart, and how each party goes their separate way. So, making sure you've got something in writing before you start is really important. And I should say, we do have a collaboration agreement up on our website. It's based on musical theatre at the moment, but you can use the principles from that and alter it for any other collaboration purposes. And if anyone's got any questions about that, they can contact me.
Brilliant. And the other thing you do, if you are represented, I've in the past, when I've set out on a new relationship, writing a relationship with someone, I've asked with another writer, not with a producer, I've asked my agent to draw something up, and she's collaborated with their agent and drawn it's a very basic document, but it means everybody's protected, and it's a bit like signing a prenup before you go into a marriage, really, isn't it? Fantastic. Yeah. So, Robert, you touched on the steps as writers we should take to protect our work from the minute we put pen to paper. I know for myself, I do try and keep, it's easy with Dropbox and all those kind of things to keep lots of different files. And every now and then I have a think about it. How long should you keep all your different drafts and what have you? And have you any tips for writers establishing their sort of vault of copyright?
Well, I would say keep everything forever. Don't throw anything away. But then I'm that type of person. I never throw anything away. So, the great thing these days is you don't have to keep drawers and files full of paper script. You just put everything onto a disk or something, and you can get thousands of documents on that, and just keep those. You don't have to keep it all on your hard drive on your laptop or whatever, but don't throw it away until you're absolutely, if you're certain that this work is just finished, it's never going to see the light of day, well, maybe you can get rid of it then. But otherwise, keep everything. Why throw it away?
Absolutely. And in terms of when you start sending that idea out, is it a good idea to keep a good record of where it's gone, who's read it?
Absolutely. Yeah, so just as important as keeping records of what you're creating is keeping records of where you're sending things. Personally, I would never send out an unsolicited script. I would always, if I didn't know the person I was sending it to, I would always make sure that I'd contacted them and asked them if they wanted to read something that I probably wouldn't send them a script anyway. I'd send them a pitch or something to start with to see if they were interested in reading something more. So don't and keep a record of who you've sent it to. If you have an agent, I'm sure they will do the same. If you don't have an agent, you have to be your own agent. So keep good records of who you're sending it to, and equally important to that is make sure that you have the copyright symbol, the little C in a circle, and your name and the year on the script, and that you also mark it confidential. In an email, you should say why you're sending it to the person, and if you don't want them to send it to anyone else, say that. Say, don't forward this to anyone else.
Yeah.
Because that way, it's not just about copyright, it's also about making sure that you establish that you're sending it to the person for a specific purpose, and you're not giving them permission to send it to anyone else. Because this is where, again, I'm sure John would agree, horrendous problems start to arise, because one producer shows it to their friend, and the friend, and all these, and this suspicion starts to arise very easily in these circumstances when you're worried about has your work been copied by someone else, as who could have seen it.
Yeah.
And the way to try and control that is right at the start, by telling people what you're giving them permission to do with your work.
Yeah. Now, here's a difficult question to ask, and I think all three of us should weigh in on this. How prevalent do you think, or how big a risk do you think that there is that someone's going to nick your idea? How nervous should we be?
I'll pass that with Don.
I mean, there's kind of two answers to this, really. You'd hope not at all. You'd hope that actually everyone you're sending it to is going to be acting in good faith, and that and the law will do its job by protecting you, and you'll be able to take remedies against it. However, this is still absolutely the case that you should be taking every step that you can to make sure that you're protected. So doing those things, as Robert has said, and keeping those updated records every time you make an alteration, and keeping those records of who you send it to, I think that's what's really important, because then you can have some peace of mind actually over, do you know what, I've done the best I can to make sure that my work's not being copied by a third party. And if you do that, the chances are, if anyone does then copy your work without your permission, you'll be able to take action against them.
Yeah.
I think from a writer's point of view, I'd say it's something you do feel enormously nervous about, because it's your baby, that precious thing that is your idea. And there's often a frustration when almost by magic something turns up on television that seems to echo what you've been working on, but often that is zeitgeist. But if you've established a good chain of who you've sent it to and all the rest of it, we can check up on whether it was in the ether or it was someone nicking your idea.
Yeah. Can I just add a follow-up question?
And there are. Yeah, go ahead.
I was going to say, like, how unique does an idea need to be in order to gather copyright, Robert? If I sent someone a treatment saying, I'm gonna, I want a fantasy film with dragons and witches, and I just sent that off, would that be enough to gather me copyright?
No. I mean, so there's a phrase which is a bit of a cliche, but unlike maybe most cliches, it's actually right, and that is that copyright protects the expression of an idea, not the idea itself. And what that means is that the more detail you put into something, the more expression means is the actual kind of written form, the actual work itself. The more that is developed from an idea, then that's where copyright exists. That's where it protects the expression of an idea, not an idea. So if you have an idea about, oh yeah, I'll write something about dragons and a faraway kingdom in the heavens or something, that's not enough. That's just a basic idea. But if you write 250 pages of developing wonderful characters and situations with brilliant plot twists and everything, then that will be protected by copyright, because the detail is there in the script. That the basic idea behind it is not protected by copyright. And that kind of comes back to what Lisa said about the zeitgeist. The fact is, we're all influenced by everything around us, you know, the political situations, or, you know, other works that we've seen and heard, and, you know, trends and all sorts of stuff. And so you shouldn't be necessarily surprised that other people are thinking along the same lines as you. The important thing is to take your own work and develop it into your own thing, to make it your own baby, as Lisa said, and that's how you get the protection.
If you're thinking that you've got copyright on writing a drama about COVID lockdown, you really haven't.
Yeah, you know, there's probably going to be thousands and thousands of people writing about that, like right now. So, you know, it isn't going to be your exclusive idea.
Absolutely. So, if the worst does happen, and you hear about a TV show that's been commissioned and it sounds awfully similar to something that you've been working on, what happens next? So that's both to John and Robert, because Robert, you're looking at it from a legal position, and John, what can we as the guild do for anybody who feels that they've been plagiarised?
Yeah, thank you, Lisa. Yeah, we have had a few of these as well. And, you know, normally what happens is we'd have a look at, we'd have an initial assessment. You know, we'd look at those things that Robert's already mentioned. You know, have you kept records to show that the idea is yours, the work is yours? Is there an identifiable link between you and whoever you think is copying the work? If you've just had it saved on your hard drive and that's not, you know, seen the light of day for 50 years, chances are, you know, it is just one of those things that, you know, someone's had the same idea at a similar point. You know, how substantial is the copyright work? You know, how substantial is the copying? You know, if they've taken one line of dialogue from 500 pages, well, that's probably not enough for us to be able to do anything about. So we'd look at that, we'd make an initial assessment, and we'd kind of say, yes, okay, we think there's potential here for a copyright breach, or no, you know, and we'll tell you why. And if there is, we think a copyright breach that's taken place, I'd then normally refer to someone like Robert and say, look, I think we've got a copyright breach case here. Can you confirm from your point of view, from a legal point of view, does this look like a copyright breach case? And if so, what's the best route forward? And it also depends largely on the member as well, you know, what it is that they actually want us to do with the situation, you know. And if something's already gone out, it's been broadcast, and it's out there, what kind of recourse is there then for action to be taken? Is it a case of making sure your credits properly put on there? Is it making sure you get some form of financial settlement? And these are all things that we then look at to try and determine, actually, for you in your context, what is actually the best route forward.
Great stuff. Robert, how easy or hard is it to go down this road and prove copyright? Is it often successful, or is it the other way around?
It really depends on the circumstances, you know, but the key thing really is the link between the two works, the access that the person you think may have infringed the work has had to your work. That's really the key thing, because it's called copyright because it's about copying. So the right only extends to someone who's copied from your work. If they come up with the same idea independently, even if they are staggeringly similar, without that link between the two works, that access that the infringer has had to your work, there is no case. You know, even if two people came up independently with exactly the same idea, the same script, you know, that's kind of unusual, but you need that link somehow. And without that, the case isn't really going to go anywhere. And then, you know, once you've got the link, it is about how similar are the works, what are the similarities, and that's not just textual similarity in terms of, you know, copied lines, but about the narrative progression, themes, all of those things can be protected by copyright as well.
Sounds incredibly complicated.
It is, yeah, and you know, I spend so much of my time reading scripts back to back and having to kind of, you know, look at what are the similarities between the two? You know, yeah, in that way, not just in terms of, oh well, that's the same line, but in terms of how does the thing progress? What are the themes? What's been taken? Is what's taken original enough to form a copyright? So yeah, that's why I'm saying keep the records to start with, because it makes things so much easier.
Absolutely. A pinch of prevention is better than a pound of cure, as my gran would say.
Absolutely.
It sounds like something that if you go down that road, you really need the guild at your back to support you pastorally as well and emotionally as well as legally. John, do you agree?
Yeah, absolutely. And you know, it is one of those situations that is awful for any writer to think that they have had their work stolen and ripped off. And we'll always do everything we possibly can to kind of explore every avenue, you know, to make sure that, you know, we can make, you know, to make sure that if that has happened, that we do help you get some recourse in some way, shape or form. And it, you know, even if it is just a case of them providing advice of, okay, well, you know, you've had something happen this time, but also here's how you can make sure it doesn't happen again. And, you know, sometimes it is also a case of learning from mistakes.
Moving on to, let's say you've got your idea, you've established your copyright, you've made sure you've kept your records, and now you're out there talking to production companies and publishers and all that kind of thing. What should you start putting in place when you start to get interest from production companies and development executives and people like that?
Well, I guess that's going to depend on the, you know, the type of project and what they're doing with it. So that's probably going to be sort of driven by the production company. But very often the starting place, particularly with films, although it's more prevalent now with television as well, is an option agreement. Yeah, and so the important thing to say about an option agreement is that it is not a agreement to, it is not a transfer of rights in your script. Yeah, you're not selling anything to anyone at that stage. But a lot of option agreements are not really very kind of clear about that. So, you know, I'd say option agreements are probably one of the most misused agreements in the TV and film industry.
Robert, could you just quickly go through what an option agreement is then in that case? Because I think there's an awful lot of confusion and misunderstanding around about what actually an option agreement is and what it does.
Yeah. Okay. So an option agreement is basically an agreement that says that you're giving the option, either the choice, if you like, to a producer to buy your script at a certain price at a certain time in the future. Yeah. It's not transferring the rights at that time. What it's also saying is that you won't sell it to anyone else during the option period. Yeah. So that the producer gets the right to go and try and raise finance, or to try and get a broadcaster or commissioner on board, whatever they're trying to do. Yeah. Knowing that they can acquire the rights in your script, but they're not paying for that at that point. They haven't bought the script at that point. They haven't paid you for it at that point. What you should get is, because you are basically, you've tied your hands, you say, okay, I won't sell it to anyone else, I'll give you this exclusive option. You should get a fee for that. Yeah. You see a load of option agreements which are, the option fee is at £1. That is not enough. You are giving up something when you sign the option agreement. You're giving this person the right to acquire the script, and you can't do anything with it during that time, and that's worth money. If the producer won't put money into it, then they probably don't want the script.
Yeah, they have to put their money where their mouth is. Hands have to go in pockets. And
yeah, that's right.
Moving on from that, what is a writer's agreement? Once maybe they're interested in getting you going.
Yeah, so with the script agreement, this is the point where rights are going to transfer. You've written the script, you own the copyright. That we already establish that. With the writer's agreement, you will be transferring some or all of the rights in the script to the producer or whoever. And the most common ways of doing that are either by licensing the rights or assigning the rights. The difference is that an assignment is like a sale. You actually sell those rights to the producer and you don't own them anymore. With a license, it's not a sale of the rights. You were just giving up certain rights during the license period. So it's a bit like, going back to the real property analogy, it's a bit like the difference between if you own a house, you sell the house to someone else, you move out, the new person moves in, and that's it. You've got nothing more to do with with that house. And letting or leasing the house to a tenant, where the tenant moves in, they live there for the period of the tenancy, and when the tenancy is done, you can move back in or you can let it to another tenant. Yeah. Okay. So that's like a license. Assignment is like a sale. Yeah. Obviously, we would prefer it if the TV industry ran on licenses, because that way writers retain their rights. But unfortunately, the industry these days pretty much works on assignment. Yeah. Yeah. And so you have to be kind of clear about what you're doing when you sign an assignment of copyright, because you're giving up your rights. Basically, you're selling them, and whatever you're going to get is going to be in that contract. Yeah. Yeah. So you've got to make sure. You've got to make sure that you know the sale price is right, and also whatever other rights to royalties or other fees, whatever other exploitation rights you're going to have are in the agreement. If they're not in the agreement, you won't get them.
No. So, and that's everything. That's, if you're J.K. Rowling, you want to make sure that you're getting 50p on every wand and Gryffindor scarf that's being sold. So it's making sure all that's in there.
Exactly. Yeah.
Yeah. Yeah. And then finally, format agreements. That's for the whole idea for a series, if I'm right in thinking.
Yeah, that's right. So if you think that the script is going to have a life beyond that initial script, if it's for a whole series, things you haven't written, and maybe you won't write all of the scripts, then you need to think about a format agreement, because that will basically cover the rights in the script, in the characters and in the situation that you've created outside of that individual script. So if there are remakes or subsequent series, using the format of characters, situations you've created, that will be covered in the format agreement.
Great. So, John, that sounds incredibly complicated, and if you are just starting out on your writing career, quite intimidating. How can the Guild help with all this kind of thing?
So, yeah, I mean, in a few ways. So, first of all, we have collective agreements with a large number of employers, such as the BBC, PACT, and such like. And with them, we have agreed minimum fees, terms and conditions, and contracts. So the first thing I'd say is look to work on Writers Guild agreement if and where you can, because by doing that, you'll know that you've got some minimum basic protections there. We've negotiated for writers collectively as good as deals as there really is. But if you're not working on Writers Guild agreement, you could then send us that agreement. So if you're a member, send us the agreement, we'll put it through our contract vetting process. So either I'll have a look at it or I'll send it to someone like Robert to have a full look, have a full vet, and to go, well, actually, here are the issues. This clause doesn't quite look right. This isn't in your advantage. Oh no, that option agreement's for £1. You should definitely be looking for more than that. We'll be able to help you identify where there are these issues so that you can go back and negotiate a better deal for yourself.
Fantastic. And if you are negotiating with a company that isn't covered by WGGB agreements, what should you be careful about?
So it depends on the agreement. So if we're going to have a look at option agreements, first of all, there are a number of clauses which I see come up time and time again that causes an issue. The first one is, as Robert I think has already identified, the initial payment for the option period. If you see that it's in there for £1, it definitely should be more than that. You know, the Guild, we have our free is not an option campaign, and we recommend, and I see quite often, around £1,000 for a year's option. With certain caveats within that as well, around, you know, they can also extend it for a year, so they get 2 years, and then they have to pay you another lump, again, another £1,000. The other clauses that I often see that cause a lot of problems are around particularly turnaround clauses. So what a turnaround clause is it basically says, right, after the option, if they do acquire the rights, they do say, okay, here's the purchase price, we're going to pay you a lump sum to actually get those rights. But then something happens, they don't actually go ahead and produce your work. You then want to be able to have the rights to be able to reacquire your rights. So often there can be some quite poorly worded turnaround clauses that don't make it exactly clear how and when you're going to be able to actually get those rights back, or how much it's going to cost you to get those rights back. So normally you're going to want something in there around actually how much it is you're going to need to pay in order to get those rights back. There's all sorts of things, you know. Also, if you're going to be looking at the purchase price, if that's going to be in there, you're going to want to make sure that's really quite detailed. And one thing I'll normally say is, you know, if someone says, oh, you'll get 2% of the production budget, which is something I see quite a lot of, if they set the production budget at 100 quid, well, congratulations, you get £2 for that assignment of rights. So having some kind of floor in there that says actually you'll get a minimum payment for the transfer of those rights is quite important as well. Robert, is there anything else you think within option agreements that cause particular issues or right issues particularly look out for?
No, I think we've covered pretty much everything. Yeah, I mean, again, it's important to stress that it's not a transfer of rights at that point. It's about basically giving the producer the right to acquire the rights at a later stage if they can go ahead with the production.
Fantastic. So we're in our sort of last 10 minutes now. So if you two are happy with that, we'll come to questions. I think Nadine's been looking at them as they've been coming up on the chat. So if you want to ask a question, can you do it in chat, please? Not out loud. That would be great, because Nadine's been looking at those. So what's our first question? Oh.
Don't mind whatever you think is interesting.
I think it's Nadine gone. Okay, so Adrian asks, I understand the value of taking any physical steps to protect your work, but sending to production companies, etc. I've heard that on writing advisor sites, now we could talk at length of these, that putting copyright symbols and watermarking your work puts people off. What's your feeling on that, Robert?
Absolutely not. I think it's actually quite the reverse. If you're showing that you're treating your work as a professional and you know what your rights are, I think people will respect you, and you know you'll be treated as a professional. There's absolutely no harm whatsoever in putting a copyright symbol on your work. And if anyone says, oh, well, I'm not looking at it because it's a copyright symbol, frankly, they don't know what they're doing, and you don't want anything to do with them.
No, and I would, you know, I'd reiterate that and across the board say, look, you are usually respected for standing up for your rights, whether it's on payment, on how you are treated in a writer's room, across the board. That's, you know, that's the soul of the Writers Guild at the end of the day. And very rarely is someone who's a good actor, a good producer, a good director objects to you strongly and politely standing up for your rights. So if someone bounces back at you on that, they're probably not worth working with, to be quite honest with you. Sam says, what about scripts written with an idea by someone else? So if someone's come to you and I've got a great story, every writer's heard that from every taxi driver they've ever been in a car with. How does the copyright get shared then?
Well, again, that's going to be the situation where you'll need a collaboration agreement of some sort. Yeah.
Yeah.
If the person who's come to you with a great idea is probably not going to be the owner of the copyright. However, you know, you may want to work with them to develop the idea in some way, and you know that might mean that you want to give them you know, some kind of credit for that or something. You know, the situations are infinitely variable, but what you don't want is to take the idea, write the script, have it all, you know, premiered for production and everything, and then the guy pops up again and says, oh well, that's my idea, I want 50%. You know, you want to get that tied down before you start, and so you need to deal with that in writing, in some kind of agreement that says what each person is doing and who owns what.
And would that true for example, if you're working with another writer but they've created, let's say, a novel, you've got the rights, would you need a similar agreement then to who gets to do what?
Yeah, absolutely. Yeah, because if you're thinking about adapting a novel, the novel is obviously a copyright work, and one of the exclusive rights that copyright gives you is the right to adapt that work. So the novelist holds the adaptation right for the novel. So if anyone wants to turn that novel into a screenplay, they have to get the permission of the original novelist.
Yeah.
So you definitely need an agreement with that novelist, which will say again, you know, what they're getting, what rights they're giving you, under what circumstances, etc., etc.
Christina asks about moral rights. First of all, what are they? And is it common to be asked to hand them over?
Right, so yeah, moral rights in the UK are quite frankly a bit of a washout, because the moral rights, to start with, moral rights are supposed to be the non-property parts of copyright. So they cover things that are not regarded as being commercially valuable rights, as the, you know, right to make a film from a book and so on is. So they cover the right to be identified as the author of the work, which is known as a right of paternity, and a bit sexist, that one, and also the right not to have the work subjected to a derogatory treatment, which is known as the right of integrity.
Mm.
But because of the way that's been implemented into UK law, it is effectively useless, because these ideas come from the continental tradition of authors' rights, which doesn't just look at as a work as a piece of property, but looks on it as basically the creation of the author. And a bit like Lisa said about you know your work or your children, it kind of tries to reflect that there's an unwaverable connection between an author and their work, and the right of integrity and the right of paternity is supposed to reinforce that.
Yeah.
But in the UK, instead of being unwaverable, they are explicitly waverable, basically. So anyone can take them away from you just by you signing a piece of paper.
Wow. Okay.
That's what happens in doesn't happen so much in publishing, but in the film industry, every writer's contract will have a clause saying the writer agrees to waive their moral rights.
Fantastic. Now we've got a question for John here. We've got quite a few people in the chat asking about whether our agreements cover people outside of the UK. Do we offer help for people working abroad? So if you could cover that, that would be great.
Yeah, no, absolutely. So our agreements are for productions, by and large, that are happening in the UK. So if it's with a production company who are based in the UK, or it's with the BBC, for example, absolutely, it would be one of our agreements. If it's for a production happening in America, for example, chances you'd be looking at working on one of the American Guild's contracts and under their terms and conditions. But if you're a non-UK based writer, but you're writing company, then again that should be done under a WGGB agreement. So it's about where the productions like to be made, where the production company are based.
Right. And Matthias, he's been writing for a long time before joining the the guild, if he has a problem with something he's worked on before his membership started, would we still help him with that?
Yes, yeah, we would. So if there's an issue that pops up, or there's something going on, join is I think, make sure you're a member of the guild, because then we can help you, and let us know what's happening, and we can then provide you with specific bespoke advice based on you, your situation, your circumstances, and the individual contract as well.
Fantastic. Robert, I've got a question from David here. If a producer likes your short pitch and then hires you to develop it to a treatment, should the payment automatically give them full ownership of the copyright?
No. They shouldn't buy your your idea just with a treatment payment. Yeah, the treatment payment should just cover the development work you're doing on the treatment. You shouldn't transfer ownership at that point. It's way too early. The thing to do would be to cover it with an option agreement, say, which would give the producer the right to acquire the rights at a later stage, and would cover your treatment fee for your work on creating the treatment. But you shouldn't transfer the copyright at that stage. It's way too early.
Brilliant. And I get the feeling that Emma's trying to trip us up with this one, but because I really like this question. How does copyright apply to verbatim theatre?
Right. So tell me what you mean a bit about. Did you know? I'm sorry, I'm not totally familiar with that term.
So you interview people and you lift their dialogue and turn it into a play. Right.
Okay. So copyright has to be recorded. Copyright work has to be recorded in a material form, as we've already discussed, like being written down. So ordinary conversation is not normally subject to copyright. However, once you've recorded it, then it's at least arguable that the person who's spoken those lines is the owner of the copyright, because they've created the dialogue. And so it depends on the situation. There's a standard sort of kind of idea that if you interview a person and provoke their responses basically through the interviewer's questions, then it's the interviewer who owns the copyright in the piece that they've created through their questions. But that's not in any way set in stone, and individual situations could easily vary. So again, it comes back to, you need permission. I would, if before I went to public with something like that, put the effort into creating a piece of work out of it, I'd want to make sure that I had the permission of the speakers to use their work.
To get a release form.
Yeah, some kind of release document. Yeah.
Great stuff. We're nearly out of time, and I can't quite believe that, because this is absolutely flown by. So I'm going to ask Robert and John to give just one, and I really apologise to anybody's questions we haven't got to. It feels like that maybe we need a second session on this. It's just Q&A, because there's lots of questions. So I'm going to ask Robert and John both to give us one final advice for writers as you leave this Zoom session and put your fingers to the keyboard. Robert.
Well, I would say two things, which have been sort of been the theme of the whole thing. Approach the work in a professional way. If you don't have an agent, you think that you've got to be your own agent. So you're going to have to basically keep records, keep control of what you're doing, present yourself in a professional way. And the other thing I'd say, obviously, is join the guild. You get a fantastic service for really very little money. So it's well worth joining the guild, because people are out there doing this work for you and trying to keep the whole industry on track for writers.
John?
Yeah, I mean, I'd underline the join the guild message, but I think apart from that, the other thing I always say to writers as well whenever they contact me is get an agreement in place. You know, just get something written down in place that we can then have a look at, we can vet, we can make sure that you're entering into that relationship as it should be, and that will then prevent you from hopefully having any issues down the line.
Now, mine was going to be join the guild, but what I'll extend that to say, the point of the guild is so that writers at whatever stage they are at their career do not feel alone. So not only can you contact John through the office, there are lots of email addresses on our website of people you can get in touch with. If you're into video games, you can get in touch with our video games chair. You can even get in touch with me. Don't be alone, even if you feel it's a silly question, just come to us. We've got a wealth of experience. Most of the people who do the work for the guild, apart from our incredible staff, are working writers who've probably gone through what you've gone through you are going through in your career, so we can help you. And it's not just the legal advice, it's the emotional support as well. We're all in it together, so we're there to help you. So yeah, join the guild, I think is ultimately the message. So we've run over a little bit, and I want to say a massive thank you to Robert, not just for this session but for everything he does for the guild. It's absolutely fantastic having someone so knowledgeable in our corner. It's wonderful, and I'd like to say thank you to John as well, because you do a great job, not in the office at the moment in your front room, but great stuff for writers. And as I said, do get in touch with us if there's anything we can help you with. That's what we're here for, and thank you very much for coming to this session. It has been recorded. When it's edited, it'll be up on our YouTube channel, so anything you've missed, you can come back and have a look and make the notes. Thanks very much for joining us.
Thank you, everyone.
See ya. Bye.
Bye.
Bye.